Good morning, friends. Namaskar, Sasriyakal, and Adab. This is my 276th video, and this video will be covering some definitions and a particular word, West or Westments. Now, what does CLA rules define these lands, 1937 or 1925, in its various definition? A1 is defined land which is actually used or occupied by military authorities for various fortifications, bungalow, aerodromes, and whatever. A2 is defined land which is not actually used or occupied by military authorities, but to the use of occupation, which for any other purpose except temporarily for specific military objections. B1 is defined as land which is actually occupied or used by the War Department in the administration and various European cemeteries and maybe central government or defense departments issues. B2 is defined as which is actually occupied or used by or is under the control of the department of the provisional government. Now, this meant state governments. Any department of the state is B2 land. Now, B3, which we are, is land which is held by any private person under the provisions of these rules, or which is held or may be presumed to be held under the provisions of the Cantonment Code of 1899 of 1912 or under any executive order previously in force, subject to conditions under which the central government reserves or have reserved to themselves the proprietary rights in the soil. Accepted. B4 is defined, which is not included in any of the other classes. Very interestingly, I just came across B5 land in Meerut Cantonment, which is saying that which is not defined in any of these lands. Now, whether was it category 3 land? Now, very interestingly, nobody is mentioning category 3 lands here, which the CLA rules in 1925 as well as 1937 have spoken of, which are private lands. Now, CLA rules, or if you read section 4 of it in 1925, very clearly says that all lands which vest in her majesty. Now, whether vesting proprietary rights in the land and vest has not got a connotation and has to be fixed construed in the context of the provisions of a particular statute. Now, this was said in Siddha Veshwar Prasad versus Ram Swarup, AIR 1963, Patna 412. A full bench judgment which clearly read the word West is a word of variable import is shown by provisions of Indian statute. For example, Section 56 of the Provisional Insolvency Act 5 of 1920 empowers the courts at the time of making of the order of adjudication or thereafter to appoint a receiver for the property of the insolvent, and further provides that such a property shall thereupon vest in such receiver. The property vests in the receiver for the purpose of administering the estate of the insolvent for the payment of his debts after releasing his assets. The property of the insolvent vests in the receiver not for all purposes, but only for the purpose of the Insolvency Act. Now, this is very important. On the other hand, Section 16 and 17 of the Land Acquisition Act 1 of 1894 provides that a property so acquired upon the happening of certain events shall vest absolutely in the government free from all encumbrances. In the case contemplated by section 16 and 17 of the property acquired becomes the property of the government without any condition or limitation, either as to title or possession. The legislature has made it clear that the vesting of property is not for any limited purpose or limited duration. It would thus appear that the word vest has not got a fixed connotation, meaning in all cases that the property is owned by the person or the authority in whom it vests. Now, in section 4, what did the Queen say? All lands in cantonment vest with Her Majesty. It may vest in title, or it may vest in possession, or it may vest in a limited sense, as indicated in the context in which it may have been used in a particular piece of legislation. So, friends, the provisions of the Improvement Act, particularly Section 45 and 49 and 54 and 54A, when they speak of a certain building or a street or a square or other land vesting in a municipality or other local body or in a trust, do not necessarily mean that ownership has passed to them. So, this is very important. Now, all cantonments were municipalities. Ambala cantonment was a declared municipality in 1862. And the Cantonment Act 1864 gives the cantonment magistrate a sub-registrar power. That means it is a sub-district. And all rules were governed under the municipal acts at that time. So we need to understand. So this vestment is not with the government. The Fruit and Vegetable Merchants Union versus Delhi Improvement Trust, AIR, 1957, Supreme Court 344. At page 353, the word West in section 38 of the Central Province and Berar Municipality Act 1922 has only a limited effect. Now, when was CLA rules passed? 1925. Where is section 4 speaking? 1925. This is a judgment of 1922. So far as municipal towns, walls, gates, public streets, etc., drains, roads are concerned, the vesting section 38 bus must be construed as to give to the municipality the interest in the property that is compatible with proper exercise of the powers in relation to those things given to the municipality under the Act. 1958 MPLJ 585. The word West is not a word of fixed connotation or meaning. It has several meanings depending upon the context in which it has been used. The meaning of the word West given in Black Law's Dictionary, 4th edition, is to give an immediate fixed right of present or future enjoyment to clothe with possession, to deliver full possession of land or an estate, or to give season. Now, these words which have been used, season specifically, I'll be making another video on this. Giving details, it has been said in this dictionary that the normal sense of the word is to indicate present and immediate interest, as distinguished from one that is contingent. The Webster Third International Dictionary, the meaning of this word is to place or give into possession or discretion of some person or authority. The other meaning given is to give a person a legally immediate fixed right of present or future enjoyment. We have that. So in Richardson versus Robertson, 1862, 6 LT 75, dealing with the same expression West, used in the local act, Lord Canworth observed as under, the word West is a word at least of ambiguous import, prima facie vesting in possession is the more natural meaning. The expression investure, clothing, and whatever else to be the explanation as to the origin of the word, prima facie rather to the enjoyment that to the obtaining of a right. But my lord said, I am willing to accede to the argument that was pressed at bar that by long uses, vesting ordinarily means the having obtained an absolute and infeasible right as contra distinguished from the not having so obtained it. But it cannot be disputed that the word vesting may mean and often does mean that which is it primary, etymologically significant, namely vesting in possession. So, friends, now I have tried to explain vesting and how courts, starting from 1862, from 1922, I have explained, and in CLA rules, why did the Britishers use this word vest? Dealing with the word vest with reference to the provisions of a local act, Willis Judge and Hyde versus Charlton in 1862, CP 104, at page 116, held there is a whole series of authorities in which words which in terms vested the freehold person appointed to perform some public duties such as canals, companies, and boards of health have been held satisfied by giving to such person the control over the soil which was necessary to carry out such objects of acts. Therefore, the word is clearly freehold. Therefore, vest does not have a fixed connotation or meaning. Vesting of right, title, or interest has the object of divesting the intermediaries, where as the vesting under section 117 of the UP Zamindari Abolition Act and Land Reforms said, has the limited person of placing a sabha into possession for the purpose of enabling the sabha to acquire present and immediate right in the same. When the reference to the context in section, the word west has been used in section 117, subpara 1 of the said act, it does not mean that the Sabha was conferred with absolute title or right over the things mentioned therein after divesting the state of its title. The Sabha has been given the rights of superintendence, management, and control. Title over these items regarding notification under section 117, subpara 1 has been issued still remains with the state. Now, here the interpretation is now something where the court is saying in this particular case that the Sabha under this section is vested with some particular rights, but the title remains with the government. In the earlier part, it had said even if you are in possession, you are a freehold possessory right holder. So now we have to read has been issued still remains with the state. It is this retention of the title that justifies the power of resumption under section 1176 of the Act. It is not correct to say that the state is merely a formal owner and does not have a paramount title. With the distinction of phraseology used in subsection 4 and 6 to that of sections 117 subpara 1 of the Act, it cannot be asserted that the same was done by way of redundant caution and no special significance could be attached to it. The distinction made is obvious, deliberate, and purposive, incorporated to achieve different objects. Hence, Section 117 of the Act, when it speaks of certain things vesting in the Sabha, it does not mean that ownership has passed thereon to the Sabha. AIR 1976, Allahabad 21. So the law vesting is to give an immediate secured right to present or future enjoyment. One has vested rights to an asset that cannot be taken away from a third party, even though one may not yet possess the asset. So vest is having a different concept. The concept can arise in any number of contexts, but the most common are inheritance law, retirement plan law. In real estate, in my earlier video, I've explained you real estate. To vest is to create an entitlement to a privilege or right. For example, now let's say one may across someone else's property regularly and unrestrictedly for several years, and one's right to an easement becomes vested. The original owner still retains the possession, but no longer can prevent the other party from crossing. I hope I've been able to explain Rule 4 very clearly, where in 1925 it said that all lands within cantonments vest with Her Majesty. Sometimes these words will actually, if not pleaded correctly, will in the constitutional bench will harm us. That is why these videos are very important. So please follow these videos. Remember, these pleadings have to be taken. And if any question, you can get back to me. Once again, as I've been saying in my culmination of my videos, we were old grants, we were revenue free grants, we were never converted into new grants, whether in 1812, 1828, or 1859, after the Resumption Act of these revenue free or irregular grants. Thank you. Good day.